So I had a little conversation with Chat GPT, the AI that is out there on the internet. And the first question that I asked Chat GPT was, are human rights considered foundational law? And it responded to me in this way: yes, human rights are often considered foundational in law, particularly in international law. They form the basis for legal frameworks that protect individuals' dignity, freedoms, and equality. Human rights principles influence the creation of both national and international legal systems and serve as a guideline for the laws and policies of the country. The AI is admitting that human rights are considered foundational law and that human rights serve as the guideline, the controlling factor, the controlling mechanism concerning laws and policies of countries. That countries are under the obligation to respect and ensure human rights because it is foundational law. So ChatGPT, does statutory law limit and abridge human rights? It's a question that I asked it. It's a question I proposed to this AI intelligence. Statutory law can, in some cases, limit or abridge human rights, but these limitations are generally subject to strict scrutiny and must adhere to certain principles to remain valid. Now let me ask those who are watching this video what this AI said right here, that they must adhere to certain principles to remain valid, that a limitation or abridgment has to follow certain principles to remain valid. What principles is the AI referring to? Because it doesn't tell us, right? It just says it must adhere to certain principles, but then doesn't enumerate or tell us or teach us those principles. So to me, the AI is not being forthcoming. It's providing limited information and limited understanding. And this is an artificial intelligence. It knows what it's doing. The AI goes on to say the following: while human rights are fundamental, they are not absolute. That's a statement that it made. So it's claiming right here that human rights are fundamental, but they are not absolute. So if you just read that first part of the sentence, right, you could get the understanding that human rights are not absolute. But we know that's not true. We know that's not what it is. Now, statutory law can impose limitation on certain rights, but these restrictions must meet specific criteria. So then it corrects itself, right? And it says statutory law can impose limitations on certain rights, not all the rights. All right then, so if it's certain rights and there are other rights that cannot impose limitation, then those other rights are absolute, but the certain rights are not absolute. Why don't you just say that? Why are you double speaking? While human rights are fundamental, they are not absolute. True, I agree. Not all human rights are absolute. But that's not what you're saying. You're making it seem that all human rights are not absolute. Then he says statutory law can impose limitations on certain rights, not all human rights. Then the AI says legitimate purpose. Any limitation must serve a legitimate public interest or purpose, such as national security, public health, safety, or the protection of the rights of others. Well, any of you that have a decent foundation concerning human rights and concerning foundational law, you know where the AI is pulling out this limitation. You understand where he is getting his information from. It says to us, any limitation must serve a legitimate purpose, such as national security, public health, safety, or the protection of other rights. These subjects that he's bringing forth These operations of law that he's bringing forth, where is he getting them from? The International Covenant on Civil and Political Rights, Article 18. Everyone shall have the right to freedom of thought, conscience, and religion. Freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. Just what the AI said. In Article 4, it says that in a time of public emergency, that the countries, they can take measures and they can place limitations upon certain human rights that are listed in the covenant. And then it goes on to say in subsection 2, no limitation, no abridgment, no derogation from Articles 6, 7, 8, 11, 15, 16, and 18 may be made under this provision. So there are some human rights that can never be limited or abridged, even for the reasons of public safety, order, health, or morals, or the fundamental rights and freedoms of others. So some freedoms can be limited and abridged, others are never to be limited and abridged. That's why we see in the Emergencies Act of Canada, where it states even during a time of emergency, there are certain rights that can never be limited or abridged. Even when human rights are limited, the legal process must follow due process of law. So the AI is telling you that when they limit human rights, that the legal process that they use, they must have proper operations of law, proper backings of law to produce the limitation and abridgment. And where would we find those proper operations of law? We find them in the international covenants flowing into domestic law. So if they try to use a legal process that does not follow the proper due process of law, it's of no force or effect against you. The AI goes on to say, freedom of expression. Statutory law can limit freedom of expression. These limitations are typically designed to balance individual freedom with protecting public order and other rights. So here the AI says that for the better of public order, that the freedom of expression can be limited. Well, 1 second here. We're not talking about a right. We're talking about a freedom. Then the AI goes on to say again, for reasons of public order and national security, the freedom of assembly can be limited and abridged. So both examples, right? The AI gave us public order and national security. The same subjects, the same reasons that we find in international law. But these limitations are not being placed upon a right, they're being placed upon a freedom. International standards and oversight. At the international level, human rights law sets limits on how much statutory law can infringe on rights. For instance, the UDHR and the ICCPR establish standards that member states are bound to respect. These instruments allow for some limitation. So some limitation, not all limitation. And the controlling mechanism against domestic law, the controlling mechanism against statutory law in your country is the human rights instruments that have been brought forth on the international level. Statutory law can limit human rights in specific, narrowly defined ways. But these limitations must be reasonable, justified, and proportionate. Human rights remain a cornerstone of legal frameworks, and any restrictions placed upon them are carefully regulated and subject to judicial scrutiny to prevent abuse or excessive infringement. So some human rights, some human freedoms can be limited in a narrow, specific, and defined way through due process of law. Hey chat GPT, are there human rights that can never be limited or abridged by statutory law? Yes, there are certain human rights that are considered non-derogable, meaning they cannot be limited or abridged by statutory law, even in times of emergency or crisis. These rights are viewed as fundamental and inviolable, and international human rights law specifically protects them from any form of derogation. So it's very clear, right? The AI just told you that there are certain human rights that are never to be limited or abridged by statutory law, period, even in a time of emergency or crisis. Under international human rights law, particularly in treaties like the ICCPR, some rights cannot be suspended or limited. Now notice what it did there, right? It didn't say some freedoms. It said some rights cannot be suspended or limited, even in situations of national emergency. Now they're going to tell us some of the rights. These rights include Article 3, freedom from slavery and servitude. And it quotes Article 8 of the ICCPR. 4, the right to recognition as a person before the law. And it quotes Article 16 of the ICCPR. So the AI is showing us where it is drawing its understanding from. It is saying, according to the International Covenant on Civil and Political Rights, these rights that are brought forth here can never be limited or abridged. And in Article 4, it says, everyone has the right to be recognized as a person before the law. This includes the right to legal identity. While certain rights cannot be limited or suspended, the ICCPR and other human rights instruments provide for derogation clauses, meaning some rights can be temporarily restricted under exceptional circumstances, such as during times of war, public emergency, or national crisis. However, the non-derogable rights listed above are protected without exception, regardless of the situation. So your right to recognition as a person before the law can never be limited or abridged. And your right not to be held in servitude can never be limited or abridged. While statutory law can limit or abridge some human rights, what I would say, AI, you got to change that. They can abridge some human freedoms in specific circumstances. There are fundamental rights that cannot be overridden or suspended under any condition. So you have fundamental human rights that can never be overridden, that can never be suspended, that can never be limited or abridged. And one of those rights are the right to recognition as a person before the law. Hey chat GPT, can I be forced to use the right to legal identity? No, you cannot be forced to use the right to legal identity. Rather, the right to legal identity ensures that you are recognized as a person before the law. It means that you cannot be deprived of your legal existence, and it guarantees that you have a legal identity. Well, that's horrible. I don't like that. I don't want to take recognition as a person before the law. I don't want legal existence. I don't want to have legal identity. That's what some are feeling right now. That's what some are thinking right now. But your thoughts are incorrect, right? And your position is incorrect, right? Because yes, you do want to have legal identity before the law. And yes, you do want to have legal existence before the law. But you don't want to have it as a statutory person. You don't want to have it as a statutory creature. You want to have your legal existence and your legal identity under your full legal capacity. That's the legal existence you want to stand under. However, this does not mean you are required to constantly prove your identity or to use specific forms of identification, unless there is a legal requirement to do so in certain contexts. For example, when voting, entering a country, or assessing certain services. In those cases, the law might require you to present official documents, like a passport, an ID card, or a birth certificate, but it does not force you to renounce or forego your legal identity. So the AI is being honest here. I guess after questioning it a little bit, it started to realize it better speak some truth here. And the AI is being honest here. Because it's saying that if you present your official documents, like a passport, an ID card, or a birth certificate, it does not mean that you have renounced or you have foregone your legal identity. Well, what legal identity is it referring to? Well, that of your full legal capacity. In other words, the right to legal identity protects your ability to have and use a legal identity, but it does not compel you to actively use it at all times. So you are not compelled to actively use your recognition as a person, as a statutory creature before the law at all times. It remains a choice. And your right to legal identity protects your ability to have and use a legal identity. Well, if I'm not taking recognition as a statutory creature, then I'm taking recognition as something else. And what is that? Well, I'm standing as a man or I'm standing as a woman under my full legal capacity. And that's a legal identity. And you have to take recognition of that identity, state party. The law requires that you are recognized as a person and entitled to rights. But how and when you use that identity is typically up to you. Now notice that again, right? He didn't say it's always up to you. He said it's typically up to you. Because if you stand as a statutory creature exercising fundamental freedoms, then it's no longer up to you. That's why it goes on to say, within the boundaries of applicable legal requirements. Well, if you're a statutory creature exercising statutory freedoms, then there's legal requirements upon you. And those legal requirements upon you can allow them to limit and abridge those freedoms. But if you're standing in your full legal capacity, exercising your human rights, your natural rights, your common law rights, then it is up to you when and how you decide to use recognition as a person, when and how you decide to enter into a statutory creature. All right, so Mr. Artificial Intelligence, I have a question. What is a statutory creature? A statutory creature refers to an entity or organization that is created by and exists as a result of a statute, which is a law or an act of legislation, a government law. These creatures are not natural or organic entities. Well, who's natural and organic? Men and women, but are established through legal frameworks enacted by a legislative body. Key characteristics of statutory creatures created by law. A statutory creature only exists because a law, or statute has specifically created it. It has no existence outside of the statute that gives it legal authority and defines its purpose, powers, and responsibilities. So when you call yourself a driver, you are operating as a statutory creature. You are operating within the confines of statutory law. And the powers and responsibilities and the purpose of the driver are defined within the Highway Safety Code. And outside of that Highway Safety Code, the driver does not exist in law anymore. If you designate yourself or refer to yourself as a resident in a residence, then you are operating as a statutory creature. The terminology resident was created by statutory law, and the resident only exists within the statutory law, and the resident owes duties, obligations, and responsibilities to that statutory law. But outside of the statutory law, you are not a resident, you are a man or a woman. Defined by legislation, the statute will outline the scope of the entity's function, powers, and how it should operate. It can establish specific rules, regulations, and even its structure. So when you designate yourself or you stand under recognition as a person, as an artificial person, as a statutory creature, then the statute that applies to that creature is what is controlling you. It can establish specific rules. And remember what Wagner said, rules can be good, but they can also be a problem. They can also create a problem. Why? Well, if those rules of those statutes are limiting and abridging your fundamental right, then there's a problem there. A statutory creature has legal personhood. Statutory creatures often have legal personhood, meaning they can sue and be sued, entered into contracts, own property similar to a corporation. However, their powers and operations are strictly confined to what the statute permits. So you can be an owner of property under a statutory law. You can be the owner, which is a statutory creature, of property, and you are being controlled in your ownership by statutory law. A statutory creature is essentially a legal construct designed to fulfill a specific purpose as defined by legislation. It has its existence, rights, and limitations based on the law that created it. So if you operate as a home owner under statutory law, then that designation, that standing of home owner has been created by statutory law. And through that statutory law, you have been given certain rights and limitations. You can do certain things and can't do other things. Now, this ownership is limited and abridged from your full legal capacity. All right, Mr. AI, I have another question for you. Can the right to recognition as a person ever be limited or abridged? ChatGPT said, the right to recognition as a person before the law is a fundamental human right, enshrined in instruments such as Article 6 of the UDHR and Article 16 of the International Covenant on Civil and Political Rights. It asserts that every individual has the inherent right to be acknowledged as a legal entity capable of holding rights and obligations. Well, why would I want to be recognized as a legal entity? Well, you don't want to be recognized as a statutory creature, that's for sure. You don't want to stand as an artificial person before the law, that's for sure. But you do want to be recognized under your full legal capacity. And to them, that's a legal entity. It's not created by law. It's not created by statutory power. That legal entity of full legal capacity exists long before the creation of the state. Now, this AI goes on to say, in principle, this right is absolute and cannot be lawfully limited or abridged. Well, hang on there a second, Mr. AI. Because when I first started having this conversation with you, and I asked you a question, you told me this. Well, human rights are fundamental. They are not absolute. That's what you said. You said human rights are not absolute. Now you're changing your tune. Now you're saying that this human right is absolute and cannot be lawfully limited or abridged. The right to legal recognition is considered universal, applying to all individuals without exception. It is a cornerstone for exercising all other rights, as it ensures one's capacity to participate in legal process, to own property and seek redress. Inalienability, as a fundamental right, it is tied to the inherent dignity of every man and woman, and cannot be taken away or restricted, even in extraordinary circumstances. Can it ever be justifiably limited? No. Legitimate legal or moral framework supports the limitation or abridgment of the right to recognition as a person before the law. Attempts to do so are typically considered gross human rights violations. So they can never force you into recognition as a person before the law, meaning they can never force you into recognition as a statutory creature. You can take recognition before the law under your full legal capacity, and that's a legal existence they must recognize, and they must allow you to operate under. This right is fundamental because it ensures that you are not treated as though you do not exist under the law. In practice, this right allows you to interact with society, to claim your rights, and protect yourself legally. So, having the right to recognition before the law as a fundamental human right, it allows you to claim your rights before the state party because you stand under your full legal capacity. And in doing so, you are claiming your fundamental human rights. You are claiming your rights. But if the state party did not recognize your full legal capacity, you could not claim your rights. And remember, the Supreme Court has already said, we did not create this full legal capacity. We only recognize it. But it existed long before the creation of the state. When you claim your rights before them, you are now claiming your legal identity before them. Prior to that, where there was no claim, then the legal identity was given to you, was accredited to you. You were treated as a statutory creature. But when you claim your rights to your full legal capacity, then you are guaranteed that legal identity. The Civil Code of Quebec, the preamble of that code starts like this. The Civil Code comprises a body of rules which in all matters within the letter, spirit, or object of its provisions lays down the common law, expressly or by implication. So they say when you read the Civil Code of Quebec, right, common law is expressed throughout the code. Either expressly, you can see it and you can read it, or by implication. And you're going to only find it by implication if you understand what common law is, if you understand what charter rights are, if you understand what human rights are. In these matters, the code is the foundation of all other laws. So concerning common law, the Civil Code of Quebec is the foundation of all other laws. Common law is the foundation of all other laws. And some people will write me on my YouTube channel, and they will say, well, it's just the code, the criminal code, or the civil code, and it has nothing to do with common law. While in the preamble itself, it tells you that this code is the expression of common law. If you read this code, you will find common law in operation. Article 1. Every human being has a right to life and to personal security, inviolability, and freedom. He also possesses juridical personality. So there's the distinction, right, between the human being and the juridical personality the human being can possess. You can possess that of a statutory creature, of an artificial person. You can be considered the homeowner, or the driver, or the student, or the patient, or the taxpayer, or the resident. You can take on that juridical personality, or you can stand under your full legal capacity. And under your full legal capacity, you are inviolable. And further to that, the Charter of Human Rights says that the home is inviolable. It means that it must be respected and not removed or ignored. It is often used to describe rights, laws, or principles that are sacred and unbreakable. So why is your home inviolable? Well, because it's a sacred principle. It's an unbroken law. It's an unbroken human right, natural right, common law right, that you need to have a home to live. And if you have not a home, then you will die. If you have not a home, the elements will destroy you. That's why when you have property in your possession, it is inviolable, your home. They are not to take it away from you through statutory law. That is a breach of your human right. And unless you've claimed your rights, they're going to treat you as a statutory creature, designated the owner, controlled by their statutory law. And within their statutory law, they can make you give up your property. They can take your property away from you through an act of parliament, through an enactment, through a regulation, through an order of the court. Why? Well, because you didn't claim your right. You didn't claim your full legal capacity. And they treated you and they interacted with you as a statutory creature, limited and abridged.